But they weren't working.
Good morning, everyone.
Terrific.
Good morning. It's an exciting group. Usually I get a sleepy like Wednesday morning. So, I'm Michelle Jackson. I'm the Deputy Director of the Human Services Council. I want to thank you all so much for coming this morning and giving your time to this really important topic. For people who aren't familiar with the Human Services Council, we're a membership association of nonprofit human service providers, and we do city and state policy on behalf of the sector. Immigration is not usually our area of choice and something that we have an expertise in. Obviously, it's one of the things that keeps us up at night about what's going on at the federal level, particularly as we represent organizations who have employees and serve clients across New York City who really make up the fabric of the work that we do in the city that we live in. So we're really happy to partner with the New York Lawyers for the Public Interest on a really important training today, and want to thank New York Lawyers for the Public Interest for doing really the yeoman's work here. We had to get space and send out invitations, and we want to thank this really incredible panel for giving their time to this really important issue. And I also really want to thank you all as members of the community for coming out today to learn about this issue and to represent the people in our communities who really need some guidance and our assistance right now. So thank you all so much for coming. And I will turn it over to Anna Maria from New York Lawyers for the Public Interest to talk a little bit more about this.
Thanks, Michelle. Good morning, everyone. It's really great to see you all here today. So thank you again so much for taking the time to be here to explore this topic a little further. For those of you who don't know us, New York Lawyers for the Public Interest is a nonprofit civil rights law firm that for the past 40 years has practiced in a number of different legal areas. The Pro Bono Clearinghouse in particular works to connect nonprofit organizations with pro bono attorneys at New York's top law firms. So if any of your nonprofits have legal questions, you can feel free to come up to us after the event, and we're happy to sort of talk with you about that and the services that we provide. We're committed to helping nonprofits thrive by providing resources, building capacity, and developing stronger programs. And one of the ways in which we do so is by creating guides like the ones that you all have in your hands and what we'll be talking about today. This summer, we released this guide with our pro bono partners, Paul Weiss, Womenkind, Wharton and Garrison LLP, who's up here, and part of the panel, Shook and Levan, and numerous community partners that are also in this room. And so this guide is aimed at supporting the nonprofit community and protecting our most at-risk clients in the face of this new reality. Today, we'll be discussing the ins and outs of this guidance, reviewing some legal questions and scenarios, and we'll be having a very rich conversation around practical considerations and best practices for implementation. We're really grateful to HSC for all of the work that they've done and their fantastic collaboration, and we're super thankful to all of the panelists up front. So with that, I'm going to turn it over to Molly to get started.
Good morning. Thanks so much. If ever people can't hear us, you should let yourself be known. Good morning, everyone. I want to also thank you for being here today. You're all really busy leaders at nonprofits, and we appreciate your taking time to think about this important issue. We don't have time to go around and introduce all of us, but I'll tell you who you are. Many of you work at settlement houses, some at legal services groups. You work at social service organizations and at advocacy groups. Some of you are executive directors, some of you are policy directors, some of you are lawyers, some of you are social workers. And I've missed some of you for sure. I want to say a couple of thank yous as well. The Human Services Council is an amazing organization. Many of you are members, and we have done many partnerships with them. This is our sort of biggest partnership yet, and it's really a great testament to what being partners means in this sector. We feel very much that we are stronger when we work together. And in particular, I want to thank Jason Wu, who's greeting people outside, who's really been a great partner in crime on this. And I want to just quickly introduce my colleagues at New York Lawyers for the Public Interest who are in the room. Heidi Kim, who I think is here, who's the Assistant Director of Pro Bono Programs, McGregor Smythe, our Executive Director, who's also here. And I want to thank Anna Maria Santamaria, who you just heard from, who is also one of my colleagues who really helped make today possible. This summer, as Anna mentioned, we began to receive phone calls from alarmed leaders of large nonprofits. around New York City. These leaders, like you, were beginning to think about the current administration and its aggressive immigration enforcement, and they were beginning to question how to ensure that their immigrant clients would continue to have access to services. How would they continue business as usual? We turned to our pro bono partners at the law firms Paul Weiss, Rifkin, Wharton, and Garrison, Strzok and Levon, as well as numerous community partners who wrote and released this special guidance to nonprofits regarding immigration enforcement, and you have a copy today. This document is aimed at supporting the nonprofit community and protecting our most at-risk clients in the face of this new reality, and it's what we will be speaking about and exploring together. I want to give a very special shout out to Emily Goldberg, one of our panelists today, who put exceeding amounts of care and love into making this document you have before you. It really could not have been done without you, Emily. Thank you. Today, we hope to answer questions that many of you have and to raise awareness among our community, but we also hope to raise questions that we can't answer. And that will hopefully inform future work that we can all do together. We have a really wonderful panel assembled here for you. I'm not going to spend too much time introducing them, but I want to thank them all for making time out of their busy schedules to be here. And we've provided in our program their brief bios. I will say that each of them comes with a unique and important lens and a really great perspective. And each of them will be sharing their best thoughts, experiences, and observations about this issue. What we will be sharing today is not a substitute for legal advice. It's meant to surface important legal and policy issues and to give you tools to begin to think about these issues. As always, I welcome you to call New York Lawyers for the Public Interest if you want to discuss any of these issues beyond today. The structure for today will be a little less than 2 hours. Our panelists will talk for about an hour, and we'll spend the last hour or so between hypos and the last half hour doing questions and answers from the audience. You all have small index cards, and so as we go about talking, I would urge you to write on them as questions come to you, and if you need more, we can get you more. And we'll collect those while we're engaged in the hypos, and we'll collect them more than once if people have more than one question. We may not get to all of them, so we're gonna try to sort of do our best. So I'm gonna ask that a couple of you help us kind of set the scene, Paige in particular, and help us figure out what is happening on the ground. What's the problem that this project was really meant to address? What are the risks that we are looking to protect our organizations and clients against? And why would ICE even be at a social service provider or be at the doors of one of our organizations? What are their goals? And I was hoping Paige would help us. And here is Natalia as well, and she's going to add to that. So thanks.
My name is Paige Austin. I'm a staff attorney with the New York Civil Liberties Union, which is the New York branch of the ACLU. And I used to be an immigration attorney with the Bronx Defenders, representing folks detained by ICE in their removal proceedings here in New York. So that is the background that I bring to bear on this scene setting question. And I wanted to set this up by basically identifying 3 types of information that immigration might be looking for, and that all would implicate nonprofits in different ways. The first and the biggest category that one doesn't normally think of as being immigration information is information about how to locate a person. A lot of immigration enforcement these days is done through resources that ICE accesses in their office through a computer, through coordination with other law enforcement agencies or with other government agencies. And there are a lot of people out there whom ICE can identify as being potentially removable from the United States just through those resources. So I'll give some very common examples. One is that anytime a person is arrested, even if charges are ultimately dismissed, they are typically fingerprinted. And fingerprints on the back end, though the NYPD here doesn't intentionally share them with ICE, they go to the FBI and the FBI shares them with ICE. So that's sort of a ding if your fingerprints are in the system because, let's say, when you first entered the United States, you got voluntarily returned at the border before you ultimately were able to come into the country. Or let's say you've had a visa in the past, or you're a lawful permanent resident who might be removable. Those fingerprints would would be ones that ICE has, and that could cause them to start looking for someone and conclude that this person's in the country and they're removable. Another common example we're seeing all the time now is folks who have been ordered removed in the past but have been living here, often on an order of supervision because they're not a priority for removal. Now we're seeing ICE round up a lot of folks in that situation. So that would be another category of people that ICE already knows about. They already know they're removable. And in fact, they probably have some idea where they are because people were often reporting to the immigration court. And there's a lot of other examples of people in this category as well. We often don't know when someone gets detained by ICE, exactly how they came to the attention of ICE. But some other ideas we can get at times are we know that ICE has some access to DMV information. If someone has a temporary status in the country, that prints in New York, it prints on your driver's license, and so that's a backdoor mechanism. They can compare that with information regarding whether someone's visa has expired or whether someone has fallen out of status. So these are all ways that ICE might, through its own mechanisms, just sitting in their office downtown or wherever they are, figure out that there's someone that they're looking for. And one thing that's particularly true here in New York City is that we know that they're a little frustrated with how difficult it is to find people at times. The reason for that here in particular is that in New York City, we don't have we have a detainer law which prevents ICE from being present at Rikers Island and also prevents, in most cases, coordination between Rikers Island and or between the Department of Corrections and ICE. And so as a result, while in most localities around the country, ICE is able to detain a lot of people and fill their beds through raiding the local jail, here in New York City, they can't do that. And so ICE has said publicly that it's a source of frustration with New York City that they have to go out and track people down in order to, feed the beast, as it were. And we also know, due to the ongoing dispute between the federal government and localities they call sanctuary cities, that that the federal government at the current time considers locating information that might go to helping to find someone they already know about to be immigration information that they think they're entitled to under federal law, which is a little crazy because locating information obviously isn't the same as someone's immigration status. But that's their position. That's what they've said to New York City as recently as a few weeks ago is, you need to provide us immigration information that includes the date someone's getting released from Department of Corrections custody, for example. This is true nationwide. It's particularly true here. The ways that they would try to locate someone, let's say this person, your fingerprints popped up or there was something else that caused ICE to know that you're out there in New York City or in the United States and that they're looking for you. At that point, we see a lot of efforts put into targeted attempts to find people. And very often these involve what ICE calls ruses. One could think of other words to describe what they do, but they frequently will use ruses in order to attempt to get information about where a person is. So for example, let's say they have an old address from perhaps an old court case, and now that's not where the person they're looking for lives, but it's where a family member lives or someone who knows the person that they're looking for, or they have a phone number, but they don't know where the person lives. They will often self-present as law enforcement or police rather than immigration, and they might tell people that a common thing they say is that there's been a crime, that someone's been the victim of identity theft, or that they think that this person is a witness to a crime, and so they need to get an address or a phone number. Oftentimes, if they reach the person themselves, they actually ask to meet at a precinct or to set up some kind of coordinated location to meet with the person under these false pretenses, and what they ultimately do is detain them. So this is significant, I think, for everybody here because we don't always know, first of all, how someone came to ICE's attention, second of all, how ICE found them, but sometimes we know, often through Freedom of Information Act requests, and we do know that they will try to confirm someone's address information or confirm where they will be through phone calls, for example, to the probation department or to another entity that might have that person's address information or that might be able to say where that person would be at a particular time. So those would be calls or inquiries that one might not immediately jump to, particularly since the caller or the person might not identify themselves as immigration, but what they're looking for is a way to find the person so that they can detain them. So that's number one. Number two is what you'd more classically think of as immigration enforcement, which is finding people who, or detaining and beginning proceedings against people who are removable from the United States, though they're not people that immigration was initially looking for. And this is something that under the Obama administration did not happen as often. There were rules internally about detaining collateral people, not the folks that were, not an individual that was being sought pursuant to the first kind of enforcement action that I mentioned. And now we're seeing that sort of go out the window and more people be detained that immigration wasn't looking for. So a very common way this happens in New York State is in car stops. So if a car gets pulled over for some reason, the officer might ask everybody in the car for identification. And if someone doesn't have an identification, even a passenger, or presents a foreign identification, they might call immigration at that point. If they come to the house or to a location looking for a particular person, they might ask everyone else there for ID and might ultimately detain some of the other people, notwithstanding that those weren't the initial targets of the investigation, those individuals. And the third category of information that I think we should all be cognizant of as we think about trying to protect information is for both those categories of people, either the individuals initially targeted by ICE or people that were collateral to that targeting operation, is what we call in immigration alienage information. And alienage information is information that goes to meeting ICE's burden in court to show that a person is removable. So once a person gets detained by ICE or has a removal case filed against them in immigration court, it's not enough for ICE to say, oh, look, he has an accent, we can deport him. They have to prove to the immigration judge by a clear and convincing evidence standard that the person is not a U.S. citizen and that they're a citizen of, and they specify another country. And so they will typically submit some form of evidence in support of that allegation. The easiest kind of evidence is for someone who's had a visa or had lawful status in the past. The person voluntarily typically disclosed their information. They might have your passport if you came on a tourist visa, or if you had TPS, they would presumably have your birth certificate or other identifying information. If someone is undocumented and has not fallen out of an existing status with immigration, then the way that they prove that the person is not a citizen of the United States typically is through one of two mechanisms. One is through providing foreign identity documents. So it could be a foreign birth certificate, a foreign ID card, or a foreign passport. The second mechanism is through providing some kind of documentary evidence of admissions that the person was born outside the United States. Admissions normally come from the person who was him or herself detained, but not necessarily. Sometimes we see admissions from third parties. In other words, they went out and questioned like a person's family and said, where was so-and-so born? And it's not always totally obvious where the admission comes from. So this is something that is typically pretty easy for ICE to do, but it's still a barrier that they have to meet. And so what we see is that if immigration is detaining someone, particularly someone in that second category of people that they weren't already looking for, they're going to say, give us, where's your passport? Where's your ID? They're going to maybe search their belongings, trying to get those foreign identity documents that they're going to need before an immigration judge to prove that the person is not a U.S. citizen. And then whether or not they get those, they're also going to question the person at some length after they've been initially detained. And it looks sort of like what criminal questioning in the criminal context, except that there's no right to Miranda warnings. There's no statement to people about their rights. So they're not told, they're not told you have the right to remain silent. What you say here is going to be used in order to deport you in immigration court. And I have had clients who have actually gone through the whole experience of being picked up and questioned by immigration without ever knowing it was immigration. So people might remain in the dark as to whether this is law enforcement. Is there some kind of crime being investigated here? If someone's on probation, they might think this is something to do with their probation. So it's very unclear often to people why they're being questioned or the purpose of the questioning, and that's intentional. So, but what ultimately will happen is that someone will be asked, where were you born? How did you come to the United States? And that admission will be memorialized in a form which is then given to the immigration court in order to prove that they are not a U.S. citizen. So I'm going to hand off to Emily, who's going to talk a little bit about people's rights in that situation. But this is something that Nightclue, where I work, does know your rights presentations about how to handle and respond to questioning in that scenario and what your rights are. But I want to just at least broaden our lens before we start, so that people know that while those kinds of evidence of foreign birth might be the kinds of information that immigration is seeking from you, there could also be a broad array of other information that they're seeking.
That's really helpful. Thank you. And I think to be also clear in setting the stage, that all, especially the third one, but some of the others, make the courts, I think, a really right place. And we do know that some of these actions have taken place. Some of these raids or ICE activity have been cited at courts in New York, and there is now a lot of activity around organizing around this. But we are not aware of anything happening to date in New York at a nonprofit site. So this is all really being done as laying the groundwork for prevention and preparedness. I don't know, Natalia, if you want to add anything else in terms of painting a picture or setting the stage before Emily speaks.
Sure. And thank you, and hello, everyone. I think I'll be brief, and I'll just add two things. One of the things I wanted to add was my name is Natalia. I'm from Make the Road, New York, and I'm a community organizer. I'm probably the only one in the panel that's not a lawyer. It's my guess.
No.
But what we have seen from the community, and this is because I Make the Road, besides having our organizers who are working with our immigrant community to help for different things, we have folks who are doing specific what we call rapid response. So it's the person that's there to help somebody once they say, my loved one was picked up by ICE, what do I do? And we help people navigate. Through that system and through a lot of collaboration with IDP, we've seen that the most common way that people are being picked up, and we do call them raids because it's a rapture. Sometimes it happens in front of the kids, sometimes it doesn't, but it's never announced, and it's never like, oh, you should just come in and this is happening. It's just like, I'm going to kidnap you from your activity right now. It's courts, whether it's because they're going to a civil or criminal. There's some sort of internal checkup that's happening. What we were able to find out through a hearing because of a newspaper leak that happened earlier in the fall or late in the summer, it's that internally there's an administrative warrant that's being put out for a person by ICE, and sometimes the NYPD was picking up and was like, oh, what type of warrant is this? And they would be like, administrative. And this is what, and the NYPD said, oh, okay, my bad. And then hung up. That's what they said in the hearing, the testimony, and this is like public records. But what we know is basically that internally there had been some sort of communications with NYPD and ICE, and that's how they were finding out when somebody had to go to court, and they were waiting specifically for people outside of court. And so court has become a big thing for community members. Sometimes we're asked to go with them. Sometimes we're asked if a lawyer can go with them, just so that they can make sure that they're not being picked up right then and there. And then the other piece that I wanted to say is, and thankfully we haven't seen as much as workplace raids. They've been very minimal, of my understanding. We've definitely seen the pickup of the cars upstate New York. That has been very common. Folks forget that New York State is a border state, and that means that people can be picked up easier. If you're 100 from the border, the ICE and CBP has more rights to be pursuant and to look up people or to pursue people, and then the homes is the same because people go and have their address. But what I wanted to say is that this is a whole machine that is using a narrative of criminality to say that they're picking up people, but at the end of the day, they don't care. And they're creating a narrative of a good immigrant versus a bad immigrant. And if we fall in that narrative, bad for us. We are not judges. We're not the people who are supposed to say who's a good immigrant and who's a bad immigrant. Something that the news or fake news will portray as this is an awful person could actually be a more complicated case. And again, that's for a judge, I think, to say who's a criminal and who's not. But they're using people who were picked up 10 years ago for driving under the influence, and after that have been for 10 years with a good record. Family member, this is actually a case of someone in Staten Island, was the breadwinner in their house and was recently picked up at a court case. And they were like, well, you can stay here and fight your detention case for 7 months, or you can sign an expedited removal or like departure. And that person, for example, decided to sign the expedited thing because who wants to be in jail? So the mom and the daughter now are making like ends for themselves, a case from Staten Island. And again, this person, the charge they had was from 10 years ago. And so they don't care about people's livelihood and family and what their contributions are. They just want any minimal excuse to deport people, and they will continue to portray everyone on the media and make it believe for everyone that it's like bad criminals, but they're not, right? They're people who are essential to our lives, and people that we are seeing are being taken away from their families, and they really, really, really don't care about the families and about the damage they're doing. Whether the kids are born in the U.S. or are born outside of the U.S. So I'll leave it there.
Thank you. Thank you for also reminding us about the people behind what we're talking about. I'm going to ask Emily to kind of zoom us back in and talk a little bit about our guidance and kind of step us through, and then we're going to break it down a little bit more.
Great. Thank you, Marnie. And I want to recognize Marnie for the amazing work she did to produce this product for all of you and others in the nonprofit space. This was her baby, and she really made sure that it was a wonderful product for people that both are lawyers or non-lawyers. And with that, I just wanted to get a show of hands. If you are a lawyer, please raise your hand. Okay, so it's about half and half. I'm mostly going to talk not to you guys, just so you know. So, for those of you that went to law school, your criminal procedure book, you may remember, was like this thick. This is a fairly complicated area of the law that we're going to talk about. It's fairly fact specific, which is why your book was this thick. And so what I'm really going to be talking about now is general principles, with the caveat that we are not giving legal advice, and that each of the factual circumstances that your workplace may present can result in a different legal answer. So we're going to be talking really in broad brushstrokes. So that's my caveat for my part of the presentation. But I just wanted to echo also some of the, before I zoom in, just some of the laying the landscape issues. Because when Marnie called me to talk about this project, and I should say I'm pro bono counsel at Paul Weiss, a lot of us in the pro bono counsel community were really focusing heavily on the question of immigration raids. The administration changed. We had crazy stuff happening with travel bans. We knew that immigration was going to become a priority in a very draconian way. And we started seeing some employment-based raids at larger facilities in different parts of the country. And so we started mobilizing around the question of targeted raids in workplaces. We had never really thought about nonprofit workplaces before. That was not something that, as a legal community, we were really ever focused on. We were thinking about, farms and factories and the larger places of employment. So when Marnie first asked us to do this, I was like, oh, okay, that's interesting, but I wasn't sure how urgent this question is. And I think we still to this day don't know. But I will say that at some point when we were working on this guide, or shortly after we finalized it, there was reports that ICE was outside of legal aid societies' offices, and that set off a firestorm of concern in real time in the legal community. Make sure your clients are not going to legal aid society right now, and that's a crazy thing, right? That we're in a world where we're telling our clients not to go see their lawyers. Mm-hmm. So I just wanted to further set that scene. So all of a sudden, that just sort of made me a true believer that this was a hugely important moment for us to become educated. I think for two reasons. Number one, for you all as people who work at nonprofits and are responsible for your workplaces in some capacity, but also for you as people who are trying to serve your clients, to figure out how you can protect them and where you simply can't, so that you can prepare yourselves accordingly. So that's really what we're talking about right now. I wanted to just give a little bit of terminology also to jump off something that Paige said. We talk about ICE, which is the enforcement arm of our immigration service here in this country, but they may very well masquerade as police. I've seen pictures of immigration raids where the ICE agents are literally wearing uniforms that just say police. not NYPD, not, fill in your state or city, just police. And that's part of the ruse, right? The image of these are people that you have to listen to no matter what because they're the police. So just be thoughtful about the fact that they may be, if you should see someone who is acting as an ICE officer, they may be in plain clothes, they may be wearing something that identifies them as an immigration official, or they may be wearing something that says police. In any event, my job now is to talk a little bit about what happens if someone who is in fact working with ICE shows up at your space, and to think about what to do. The major legal framing here is a little thing called the Fourth Amendment, which some of you may have heard of. Those of you who went to law school definitely have heard of. The Constitution, questionably applicable in this country anymore, I say sarcastically. But it does exist, and we have to continue to defend it. And to do that, we have to understand what it allows and what it doesn't. And so the question of what happens when people from ICE enter your space or try to enter your space is a question of search and seizure law under the Fourth Amendment. And we start analyzing that question by looking at what kind of space you work in. And I'm going to very quickly, and with a fairly large butcher knife, i.e. not a scalpel, split these two categories into public spaces and private spaces, okay? So for those of you that went to law school, the question of what your reasonable expectation of privacy is often defined by whether you're in a public place or whether you're in a private space. And so, the ultimate public space is like on the street, the ultimate private space is in your home, but there's a spectrum of shades of gray in between, and that's where the Fourth Amendment gets to be very fact-specific, but we're going to break it down a little bit. And so, I think about when I was entering in the lobby this morning, when I said, I'm going to UJA, and the guy at the security desk laughed at me and said, well, this is all UJA. If someone from immigration came in to that lobby area, not through the security, but in the lobby area, do they have the right to be there without a warrant? The answer is yes, they do, because it's a public space. I entered that without any special permission, as did all of you. And so the right of an ICE agent to be there is fairly clear. So if they're there to just, be scaring people or to be there to try to find someone specific, they do basically have a right to enter. If one of your clients is in that public lobby area, and there's a warrant for an arrest or probable cause, that means something more than a hunch that there's been criminal activity, can they be arrested? Yes. So the lobby area, the public space, is an area of great, vulnerability for your clients. Can they take pictures? These are some of the questions we looked at in the guidance, so I'm just going through this. Can ICE take pictures in that space? Yes. But they can't disrupt the work being done or the activities being done in that space. Just like any member of the public could get booted out for causing a ruckus in the lobby area, also ICE cannot. So there's sort of a fine line there. At what point are they acting as a member of the public with the right to be there, and at what point are they disrupting the orderly activities that are taking place in the lobby? And I would say that if there's, a lot of disruption happening, then it would be appropriate to say, you're disrupting our space, please leave. What they end up doing with that request is a separate question, but I would say that if there's non-compliance with that request, you then become a record keeper. You have every right to write down what's going on, to start recording it, and then contact people like Paige at Night Clue to start talking about violations of the law. I would also say that we have other kinds of public space, certainly. I mean, my co-panelist at the library, we sort of thought of that as an archetypal public space, albeit different than a lobby, but certainly anybody can go to the library. And if you have clients who go to the library, perhaps to use a computer terminal, very common, is that a place that ICE could enter and do something without a warrant? And the answer is yes. In the library reading room, any place that's open to the public, we think yes. But again, the disruption piece is a limiting factor. We were also asked about documentation. So what if someone's at a library and they're saving work product on a library computer that everybody can access? Is that sort of open for business? The answer is yes. So public-private accessibility is sort of, again, the turning point of what we're talking about. So I wanted to talk then, if anyone, I'm happy to answer questions now or hold. Whatever.
Hold.
Okay, hold. So hold. Okay. So then we're going to talk a little bit about private space. Okay, so many of you, like I did, went through the detector and came upstairs. I would argue, and I think everybody would agree, that once I was given that entry into the elevator, I am moving toward private space. And certainly when I came into this room, I am in private space. That means that not everyone was allowed to enter, right? You had to state your business, you had to say where you were going, why you were there. Can ICE just show up and say, I want to go to the 7th floor? No, they really can't. And if you have a nonprofit which is structured sort of similarly, where you have a public lobby space, someone has to get buzzed in, someone has to be let in, that is a gatekeeper function that I urge you, and my fellow panelists will talk a little bit more about implementing these issues, to make sure that person is educated about the power they have to say no, to say you cannot come in, right? For anybody who went to law school and anyone who probably watches law shows, consent is like the most powerful way to open the door to the police, to ICE. And so if your employee is sitting at that desk or doing that buzzer and says, sure, come on in, you've let ICE in the building. And there's no legal defect with that in most cases. So educate your gatekeeper that in the first instance, consent is not obligatory, okay? So what you can do then is say, who are you, state your business, and if they say police or immigration or anything of that nature, you then say, what are you here for? I'm here to, to see, so-and-so, he's committed a crime, or, we suspect he's committed a crime, whatever. The answer is, do you have a warrant? Okay, that is the answer to that statement. Do you have a warrant? The answer to that may be, yes, I do. Well, there are two kinds of warrants, and I can't remember who, I think you, Natalia, mentioned. There's something called an administrative warrant, and then there's something called a judicial warrant. The word warrant is not the same for both, okay? So a judicial warrant is a warrant that a judge has signed after reviewing the facts of the demand on the part of law enforcement to either search something or seize someone, and it's signed within the last 14 calendar days. And that is a valid judicial warrant. It has to specifically identify what law enforcement is there to do. So it's not going to be blank. It's not going to just say you have the power to do anything and everything. The other kind of warrant is an administrative warrant, and that is typically a warrant that an ICE, Immigration Customs Enforcement agent or officer, will have signed, not a judge. This is, in my view, sort of the ruse, right? They show up and they say, we have an administrative warrant for Marnie Burke's arrest. She's an undocumented alien. We have the right to come in. And the answer is no. An administrative warrant does not require you to open the door. A judicial warrant does, okay? So we've included in the guide that we've given you all, and that hopefully you've seen before, an appendix with Appendix B and C that identify both an administrative warrant and a judicial warrant. And, I encourage you to take a look at those and really see that one looks like a legal document with a judicial signature and the other doesn't. And it clearly states that it's not from a court. So that's the most important sort of framing question that you can ask when someone shows up at your door. So again, no consent, no entry with an administrative warrant. There are some exceptions to this. Again, for those of you that went to law school, that's why the book is so big. But, if there's a real suspicion of criminal activity where the person, could be absconding to another country in that moment, can they get in? Probably. Is that likely to be an issue that you're going to face? Probably not. So I would just say, let's keep it simple for the moment and keep it at you're a nonprofit, you have clients in your space, some of them may be undocumented, some not. Someone shows up at your door, there's no sort of exigency, as we call it, but it's just sort of garden variety demand to see or see your space, come in and interview someone. You've now been told what to do. Okay. Suppose there is a judicial warrant. They have the right to come in. What do you do? Marnie and I have talked about this many times, and we wanted to tattoo on everyone's forehead, call your lawyer. And in fact, even if they show up with an administrative warrant, I think the answer is call your lawyer. And all of you have different kinds of nonprofits. Some of you are nonprofits that have lawyers on staff. Some of you are tiny nonprofits. There may be only one or two people in the building at a time. So I think it's really important that whoever that gatekeeper is, know what to do. So call your lawyer should be given as an instruction in the event that this horrible thing, which we hope never happens, occurs. And you should give that person clear instructions as to who they're calling, whether it's a supervisor who has that information or whether it's that person calling the lawyer directly. I encourage you to do that. And for those of you that are concerned and you don't have that number, that's why Marnie's here, to help you figure out whether you can find an attorney to advise you on these issues. Okay, so let's just proceed through. I'm going to try to move through a little faster, but ICE has come into your space. What do you do at that point? What do you tell your employees to do, right? As an employer, you have an obligation, perhaps your supervisors, you want to tell your people what are they allowed to do, what are they not allowed to do. If there's a judicial warrant that specifies what they're allowed to do, let them do it. If it says arrest Marnie Burke, you got to let them do it. If it says, search for documents, you have to let them do it. Don't allow people, don't yourself conceal your clients. Don't obstruct the investigation. And there are other panelists that are going to talk about this. The line between advocacy and breaking the law, we don't want to cross that line. So should you tell your staff to remain silent? I think we'll talk a little bit more about that. I think there's two schools of thought. One is absolutely. You don't want your employees saying anything that's going to cause any problems for themselves, for your organization, for your clients. Others would say you have the right to say something that objects to the enforcement action going on. I'm going to leave that for a policy decision, and we'll talk more about that. I just want to point that out, that technically, as a matter of law, you have the right to remain silent. The First Amendment also allows you to speak. So we'll talk more a little about that issue. Tell your employees or yourself, don't leave unless you're told you can. That said, if you are allowed to leave and you choose not to so that you can be a witness to this, perfectly appropriate. Taking notes, even recording what's going on is appropriate under the Constitution. Bless you.
And taking photographs.
And taking photographs, yeah. I mean, I would say that one of the great advice pieces that we got from the National ACLU when the administration changed and we all started getting hysterical was empower anyone on the scene to become a record keeper. Because ICE does not always follow the law. Shocking, right? They break the law all the time. There may have to be court actions to follow up on that, to challenge practices that are unlawful. And anyone can be a witness and a recording witness to violations. So, get out a piece of paper, ask for the officers' names, ask for their badge numbers, record what happens, either writing or video. If they try to take your phone away, you can say, I have the right to record this. We recommend doing so from a reasonable distance. Don't get in their faces, let them do their jobs. Now, if one of your clients is detained, or even one of your employees, if that should be an issue, you also have the right to ask where they're going to be detained. There are a couple different options in terms of detention strategies, close by, far away. You have the right to ask. They don't have the obligation to tell you. But I've had officers, I had a client who was being deported, and they gave me a courtesy call from the airplane. I mean, sometimes you get that. And so you might get an officer who's saying, we're going to take them to the Elizabeth Detention Center in in Elizabeth, New Jersey. You then have the right to ask this person that's being detained, is there someone I can call? A friend, a family member, and let them know that this has happened to you and where you're going. I think that's an incredibly important thing to do to protect your clients, because as I think Paige said, or maybe it was Natalia, I'm not sure, people can disappear and no one knows where they are. And it's a really hideous experience. And so I definitely encourage that. The last thing that I'll say,
Sorry,
please.
I just encourage also getting, if you get in contact with somebody after they're detained, their A number. It's a number that's given to them by immigration, and it's just the easier way to find them, especially if they, by whatever reason, get transferred somewhere else. You can find people through the A number. And usually when somebody's detained, they know right away because they're told what that number is.
Yep. Great. Thank you. Okay, so my last point is, what if you work in a nonprofit that's considered a sensitive location? So there was a policy under the Obama administration, this probably existed before Obama, but I don't go that far back on the immigration scene, where there was an active discouragement as a matter of policy not to conduct enforcement actions in areas that were considered sensitive locations, hospitals, schools, places of worship. It was a policy, not a formal rule, law, etc., subject to change at any time. Do we believe that that has been changed? I think we're getting there. I've definitely heard about actions at hospitals just this weekend. I was emailing with someone at ACLU about an action at a hospital with a child. Certainly, places of worship, I think, have been very worried about this. So is this a sensitive location protection still active, still valid? I think that's an open question, and one would say you should assume maybe not. And then there have also been policies in the past about sensitivity toward particular locations, not necessarily discouraging enforcement actions, but just taking particular care with organizations that assist children, pregnant women, victims of crime or abuse, and those with serious disabilities, either mental or physical. Again, smarter minds than I will know more about whether this is something we need to be worrying about more on the sensitive location side. But I think that's it for me. And I hope I haven't scared you too much, but have empowered you to think about where you have the authority to push back and where you have to just simply be a witness to what's going on.
Emily, thank you. That was great. I want to see whether Jeff would like to add a bit about subpoenas, because we're now talking about kind of all the planning in the world. And then what if this sort of is this extra layer where your organization is subpoenaed for records? I thought Jeff could add a bit.
Sure. Good morning, everybody. My name is Jeff Chapiga. I'm a lawyer at Paul Weiss here in New York. I want to focus on documents. I think Emily talked a lot very helpfully about what happens if they show up with a warrant, and talked about if they're seeking an arrest. But I want to talk about documents and information, because collectively you all have a tremendous amount of information about yourselves, about your constituents, and about your clients. And as Paige was saying, that could be very useful, and ICE could be coming to your organization to seek that information. I want to start just quickly by echoing Emily's caveat that we're going in with a butcher knife, and that these are very thick books and complicated areas. So this is not meant to be incredibly precise and narrow. And any time that the government is seeking information from you, tattoo on your head, talk to a lawyer first. Totally, completely agree with that. But with that said, let me dive in to talk about sort of the three main ways that ICE would probably seek information from your organizations, and a little bit about how you can respond to each of those ways. So the first is, as we've been talking about, a judicial warrant that's signed by a court, where ICE has gone and shown probable cause, and they come out with the judicial warrant, and they show up at your organization with that warrant. You have a right to inspect that warrant and to see that it is a proper judicial warrant signed by a court. But if it is, as Emily was saying, there's actually very little you can do in response. You do have to let them in, and you do have to let them look and collect for the information they're looking for. There are a few best practices, certainly. As Emily was saying, become a recorder. Look at what they're doing, take notes about what they're doing, get copies of any information. If they want to take a hard drive, make a copy, try to make a copy before they take it. If they try to take hard copy files, make copies before they take them. And make sure that whatever they're taking and looking for is properly described in the judicial warrant. The judicial warrant will lay out what kind of files, not with incredible specificity, but with some specificity, what they're looking for. And you can try to insist that they only look for those particular kinds of files. So that's the judicial warrant. Very different circumstance with a subpoena. ICE may, as part of a ruse, show up and say that they have a subpoena and they have a right to go look for files. But a subpoena that's not signed by a judge does not allow them to go looking through your files while they're on site. A subpoena is judicially enforceable. It's true, but in very different circumstances. They cannot go and search and seize your documents right there. With subpoenas, you have time to respond, and you control the response. Okay, you can go get a lawyer. You usually have a certain amount of time to respond, and you can oftentimes try to negotiate how long you have to collect files, in what manner you're going to deliver them. You really have much more control over the process with a subpoena as opposed to a judicial warrant. Another important point, and they're spelled out in the guide, is that you have you and your organizations and your clients have rights not to turn over certain types of information in response to a subpoena. There are 3 different buckets that are talked about within the guide, all of which I think apply differently to different organizations. But broadly speaking, HIPAA provides wide protections for health information and largely requires consent before protected health information can be turned over even to the government. Educational information is also protected under the Family Educational Rights and Privacy Act, FERPA. It also usually requires consent before any information about schooling or educational files can be turned over to the government. And then most importantly for legal services providers like NOPI or other organizations in the room, the attorney-client privilege and the work product protection are very important principles that allow you to protect information. If you are providing legal services to an individual and they are a client of your organization, those files are almost always protected and cannot be subpoenaed by the government. Just want to add, there's also something called an I-9 audit, which there have been rumors that those will be picking up. We haven't seen that many of them recently, but the I-9 form, as many of you know, is the form you have to fill out when you start employment, and an ICE tool that they may use to try to collect immigration information is to send you a notice that you have to turn over all of your I-9s to ICE. And those subpoena, it's basically a subpoena, but it's a very particularized type of subpoena. You only have 3 days to respond, and there's not much negotiating to be done. But again, everything that you do, consult with a lawyer as soon as you get any of these types of requests for information. And the last thing I'll save now, and maybe we can talk about questions, but whenever you're thinking about preparedness for these types of issues, the most important thing is to think ahead of time about what kind of information you have. What information do you keep about yourselves and about all of your clients, constituents, partners, funders, and where that information is stored and whether you need all of that information or not.
Great. Thank you so much. And I think the I-9 point is also a really great point. And it speaks to sort of new and creative ways that I think we're going to have to be very vigilant. So I want to switch gears and ask a couple of the providers up here who have been thinking about implementation, both Chloe and Den, to talk about some of what they've been thinking about within their organizations, some of what's worked, some of how far they've gotten, some of the obstacles they've maybe run into in looking at the guidance and seeking advice and kind of putting stuff into motion. And I thought, Chloe, maybe you could start.
Sure. Hi, I'm Chloe Wasserman. I'm general counsel at Brooklyn Public Library. We're like the 4th largest public library in the country. We have 60 locations throughout the borough of Brooklyn. And just to give you a sense of our employee base, we have about 1,000 full-time employees and 400 or 500 part-time employees. So we're kind of a large and somewhat unwieldy organization. The other point to note is because we have so many locations, we have a lot of points of entry, and so when you're talking about the receptionist, we have 60 different receptionists, and in fact within that building there's no one particular person who is the person that would interact with someone entering the building. It could be anyone who's on desk, sitting at the desk at that time, or in the shelves or whatever. So it's a little complicated. This came up as an issue because we serve many people in the community of immigrants in Brooklyn. We have ESOL classes, we have citizenship classes, we have many, obviously, books and services and computer services, and we do a lot of work in this area. So we were sensing after the change in administration that there was a chilling effect, that people who'd enrolled in classes had stopped coming to classes sometimes, that a lot of talk about potential raids or fear of raids, or, we think that was a raid. It turns out it was like Con Ed walking on the street or whatever, but people, there was a heightened anxiety amongst many of our patrons. And so the people that work in our immigrant services team and I started talking, and then we reached out to the other library systems in New York, Queens and New York Public Library, about what danger we're in, and how to walk the fine balance between, we don't want people to stop coming to our services. We think we provide amazing services for everyone in the city, but including immigrants, documented and undocumented, and we pride ourselves in serving everybody. And so we really don't want to discourage people from coming, but we also can't promise them that we're safe. As we were talking earlier, we are largely public space. Anyone can come in. And so to tell our patrons that it's a completely safe space would just be misleading. So that we reached out to NILPI, and they reached out to Paul Weiss, and it all became this document, which is amazing. So what we've done at the library is really focused on a lot of training. So we do have a document, and it's based off this document. We have our own kind of made it for our specific scenario. But we've done a lot of meetings, both mandatory and just people who are interested to come to learn a bit more about just giving them a basic overview of even what the immigration service is, some of the basic facts, and then how it might affect them if someone from ICE comes into the branch, and what kind of information they might be looking for. The helpful thing, I think, for us is people working in libraries already have in the CPLR, there's a protection of library records, our patron records. So there's a general sense that everyone knows this when they start working at the library, and there's a lot of training about this, that we never give out patron information, be it name, address, what people are reading, who's in what class. We just never give that out without a subpoena court order, and that goes through my office. And so we hope, obviously the system's not perfect in such a scattered organization, but at least there's that. I don't think that our staff would just be turning over information without realizing that that's a thing. But I think for us, talking of the challenges, has really been making that distinction with the public-private. So we know that, enter the main reading room, it's a public area, but we do have classrooms, and we're just choosing to decide that our classrooms are private because someone had to register. A member of the public can't just walk into the class if they're not registered. Yes, they're free, but there is sort of a slight barrier, and we, particularly for our adult learning areas, we do usually separate them from the rest of the floor. So that's kind of one of the distinctions we're trying to make. But yeah, it's definitely we haven't had a visit from ICE. Mm-hmm. And so I don't know how well all of our training is working, but the other thing we've done is focus very much on core librarian sort of mandate and mission, which is providing accurate information to our patrons and giving them access to information. So we have a tremendous amount of resources available to our staff, know your rights materials, and how to look up a family member that's been detained, and all those kind of things. We have a lot of links and stuff available to our librarians, and we pass that information on how to get accurate information and appropriate help. So that's kind of where we are.
Great. Thank you.
Marnie, can I just
Yes,
point out,
please.
for those of you that haven't looked at the guidance, in Appendix A, there is a sample policy and procedure document that kind of walks you through how to think about creating policies and procedures in your organization that obviously the library has done in a formal way. But I just wanted to point that out because I think we hadn't mentioned it.
Yeah, thank you. Den, I thought you would also add what you guys have all been thinking about.
Sure. Hi, everyone. My name is Dan Quincy, and I am with Womenkind. I thought I'd give you a little bit of a backdrop as to the types of services that we have to give you a sense of why it was essential for us to create a procedure regarding safety planning with all of the sites that we have. So Womenkind serves survivors of gender-based violence across all ages. We serve the Asian immigrant community. And so the survivors basically, our specialty is within domestic violence, sexual violence, and human trafficking. We offer free services on counseling, legal help, including immigration as well as family law. We have wellness groups that survivors access within our sites. So these are various wellness groups that either address the trauma of a survivor, or if they're coming from the Human Trafficking Intervention Court, which we are present in, they are part of the programming as well. So our staff collectively speak about 18 Asian languages, and we have 5 offices, 5 sites, 2 confidential emergency housing, 3 community offices, 1 in Brooklyn, 1 in Queens, and 1 in Manhattan. So earlier in the year, we also were one of the organizations that hosted and provided Know Your Rights workshops for our clients, as well as our community members. At the time, the resources that were available for Know Your Rights were really focused on when ICE is present at your door, at your home. So conversations were happening in terms of like, what do you do when you're actually in transit to receiving services with us? So through these Know Your Rights workshops and the trends that we were seeing with the advocates that are directly working with the survivors, we saw a shift of the safety planning that was happening with the survivors. So typically, our safety planning is conducted with physical safety planning, emotional safety planning, as well as technology safety planning. And that shifted to us responding to the political climate as well as the executive orders that were coming down the pipeline that really targets the immigrant community. So what happened was this sort of warranted us to look for creating a procedure within all of our community offices because, as I mentioned earlier, we hold groups within those community offices. So it was essential for us to look at, well, how would that play out in terms of when ICE is present at the door? That resulted on, that planning was happening around May or April. There were no resources for nonprofit in terms of how do we identify or make a distinction between private and public spaces. There was a contention even when ICE showed up at the Human Trafficking Intervention Court, not just outside but inside, right? And so a lot of those conversations really sort of helped us ask our own questions on how are some of these related to us. So we took a lot of the information when we actually ran into this packet. It was very, very helpful. What we did was we created an agency-wide safety drill. So we invited all of our staff basically to a training. We went over majority of the questions that were outlined in this packet. And what happened was we generated our own frequently asked question sheets. There were a lot of questions from our staff, but I think it really helped us to kind of do role plays as to, because, you know, ICE sometimes are forceful and sometimes maybe they're not. I'm learning the ruse part, which is very, very important. I think that would have helped my training with the staff to kind of identify what are happening, what are the things that are happening with ICE. So where we are is basically at this point we have a procedure that is in place for all of our sites, including the emergency housing, as well as all of and the main office as well. We have point person as to who to go to when ICE is present at the door, and what are the things that you can say. So that's where we are at this point.
Great, thank you. I'm going to ask Laura Abel to talk to us a little bit in kind of switching gears for a minute, and I guess kind of zooming out a little bit around activism and speech, and Natalia will also add to this as well. In terms of, you know, what kind of constraints we have as nonprofits in terms of what we can say, what we can't say, what's kind of fair game around these issues, because we all care a lot about these issues and may want to preempt or say something publicly or say something while any of this is underway. So we thought we would add her voice and her wisdom also to this panel.
Thank you, Marnie. So I'm Laura Abel. I work at Lawyers Alliance for New York, which, like NILP, provides pro bono legal assistance to nonprofits around New York City. I do a lot of my work with advocacy organizations. So why is that relevant today? I think we wanted to leave you with a lot of tools, things that you can put in place in case ICE comes or asks for information, and also things that you can do affirmatively to channel some of the fear and anger around this issue. So Natalia will tell you about some of the work that's going on in the community proactively to try to push back. I just wanted to leave you with some ideas about what nonprofits are allowed to do consistent with our tax-exempt status. So how many of you work at organizations that have 501c3 status? Great. That's a very powerful tax-exempt status in terms of advocacy. So that's the good news. Yes, and I work at a 501c3 public charity as well. There are some restrictions on what we can do. The big one is we are not allowed to engage in partisan political activity. But we are allowed to speak out about things that public officials do in their official capacity. So I spent a lot of time during the presidential election season counseling my clients about how they could talk about immigration without taking a position on particular candidates, one in particular. The day after the election, I sent out a legal alert to my client saying, okay, we've had some news. The one little bit of good news is that you can all say whatever you want about President Trump. He is our president. And you can say what you want about him in his capacity as a public official and the actions that he takes as a public official. That goes for the entire administration. The one place that you need to be a little bit careful is in talking about who you would like to be the next president. And when we get into re-election season, yes, we have to be a little bit careful to make sure that when we are speaking out about the actions of public officials, that we don't bleed over into and don't reelect them or vote for this person. But we can and should be speaking out about what's happening in our communities, and that does extend to elected public officials. Okay, so that's partisan political activity. The other restriction on public charities is around lobbying. We are allowed to lobby. We can lobby under the law as long as it is no more than an insubstantial part of our activities. That's a very nebulous test. But the good news is that groups that know that they want to do lobbying, and by the way, this is a very narrow definition of lobbying, so I'll speak to that in a minute. But groups that know that you want to do lobbying, there's a one-time form, it's half a page, you send it into the IRS, and it allows you to use a mathematical formula based on your total revenue that tells you how much you can spend on lobbying in a calendar year. And it ends up being a substantial bit of money. So if you're interested in that, it's IRS Form 5768. It's the easiest, most painless thing you will ever do in your life with the IRS. It takes about 2 minutes. But it's important to realize that the IRS's definition of lobbying is really narrow. So when they say that lobbying can be no more than an insubstantial part of our activities, what they're talking about is an attempt to influence legislation in two ways. One, direct contact with a public official, primarily a legislator. Or two, speaking to the public, expressing an opinion on legislation, and asking the people that you're talking to go out and lobby on that legislation. So you can say, as nonprofits, whatever you want about legislation, about a bill. You can tell people this is a bad bill. You can say we support a piece of legislation, as long as you are not speaking to a public official or their staff. If you're speaking to the public and you don't have a call to action, you don't say, fill out this postcard, call your senator, send an email to your senator. As long as you don't have that, that is not lobbying. So you can express lots of opinions about immigration legislation, for instance, without lobbying. And there are lots of things that you can do in terms of direct contact with public officials that don't involve lobbying. Information. You can always go with your members, your clients, your employees, and talk to public officials and let them know what's happening in your community. You can let them know how scared your clients are. You can let them know the human impact on families. And as long as you don't have an ask there related to legislation, that is not lobbying. That's education. And that's a really important function that we play as nonprofits in helping our communities speak to the decision makers. We also can do whatever we want around administrative action. So we can go meet with the immigration officials if we want and ask them to change the way that they are enforcing the law. That's not taking a position on legislation. That will never be lobbying within the IRS's definition of lobbying. So there's a lot that we can do to affect the way the government administers the law without engaging in lobbying. I should just say a footnote, some of the activities that I've been describing might be counted as lobbying by New York City or New York State. And if you spend enough money on that activity, you might have to register as a lobbyist. But that's kind of a different consideration that doesn't affect our tax-exempt status. It's not a limit on what we can do. It's a reporting requirement. I'm going to apologize in advance because I actually need to leave and run to another training, telling another group that it's important to advocate and how they can do it. So I won't be here to answer questions. I'm really sorry. But I am happy to talk to any of you on the phone or by email. You can find my contact information on our website, lawyersalliance.org. So
Great.
Thank you.
Laura, thank you. And I also just want to add that on the point of lobbying, those rules are complex because they also live within 3 levels of government. Lawyers Alliance does great trainings, as does Human Services Council, and a lot of us have good resources and literature, so you can reach out to any of us for that. Thanks so much. I was going to ask Natalia to also add something to that, a little bit more on activism, and share with us some information about the signage that you guys are using.
Yeah, that's actually what I was like, I want to show this.
Yes.
So this is simple, and if you have a piece of paper and pen, you should definitely write this. Our magnificent lawyers helped us come up with this, which one of our legal directors is here. So when all of this was happening, we were also like, we are a community organization also for offices. Our aim is to help immigrants. We know that a lot of the people who come to our door, or the majority, are undocumented or people in the process of adjusting status. So we kind of got worried. And I remember there was an incident, I actually now don't remember exactly what it is that happened, but that we all started talking and said, how do we make sure that community members feel more safe coming to our space, and that we are teaching our staff and we are making a statement a public statement about we are protecting our immigrants and we are not here to collaborate with NYPD or with law enforcement, but we are here for community. And so our lawyers helped us come up with a sign that has everything to do about consent, right? So they're lawyers, they know about consent more than we do. And so in the front of our office, we have a sign that we both have it in English, obviously for law enforcement agents, and then in Spanish for our community members so that they know that this is what we're saying in English. So it says, no law enforcement officer may enter a premises without judicial warrant. And then the next line is, only executive directors of Make Their Own New York are authorized to consent to admission. That's in the front of all of our offices.
Do you want to just read it one more time?
Yeah.
Yeah.
Slowly, yes, sure. No law enforcement officer may enter the premises without a judicial warrant. And then it says, no, wait. Only executive directors of Make Their Own New York are authorized to consent to admission. And so what we did was train all of our staff, especially our receptionists, that when NYPD or anyone else that may say we're police may come into the door, that all they had to do was point to the sign and say, like, look at the sign. They usually, like, the only people who have come into our offices has been NYPD for I don't know, community affair things, like nothing that has to do with enforcing the law, but more of like wanting to be our friends. And they don't like the sign. And our receptionists usually tell them you have to wait outside. And then if an executive director is not in the office, they'll look for the next director, either a legal director or organizing director, one of those. And then we'll have conversations with law enforcement outside of our premises. And they're like, well, we want to hand out this flyer. And I'm like, well, thank you. I'll take the flyers. So that way our community members know that this is not a place where they're going to like go in and by, coincidence of outreach or whatever, engage with NYPD, but that definitely we're going to be protecting our members and will not, be talking to anyone unless they have a judicial warrant. And then in the warrant, we'll say what they need and make sure that we're only compliant to that. And in that case, which we've never gotten it, the first thing we will do is call a lawyer, one of our own lawyers. And we know that we have a unique situation, which is that we have lawyers in almost every single one of our offices, so there will always be someone there to help us out. So that has been, I think, like a little bit of like a sense of relief for our members. It definitely has been for me as someone who works with the immigrant community. The other pieces that I wanted to say around advocacy, we worked really hard on the detainer law because we knew that the ICE was coming undercover at Rikers, and so we wanted to stop that. That has stopped effectively over 90% of the raids that could have happened, or the deportations that could have happened from that. The other two pieces of work that we're doing that have moved this year, one is at the state level and one is at the city level. The one at the state level talks about, and I can forward this information because it's a little bit complex, and I think the lawyers here will probably understand more why it's complex than me. It took me like forever to understand it. But it's basically saying at the state level that state agencies cannot collaborate with ICE unless there is an investigation and they have like proof of like some sort of activity in that case. They can collaborate but only share the immigration status, and that's when it kind of gets tricky and a little bit of a back and forth. But basically what that means is like DMV should not be collaborating with ICE anymore, right? We knew that DMV was sharing information. Why? Because one of our members got detained in front of their car. How are they going to get detained in front of their car? Because they have the information of what car they drive and what borough they are in like, or move around, or what, like the home address is. So that's why that executive order is important. It happened not too long ago. I want to say like a month or two ago. And we know that like everything, it's about implementation. And so we're working to try to figure out what the best implementation can be. And by that, I mean like guiding the government. Like this is more or less what we did, for example, with language access. And this is how like the implementation went. So here's how you should train your state your state employees. What we need as an organization that advocates for community members is to, if you ever encounter a case where you have proof that a state employee collaborated with ICE or collaborated to share any information, we need that for following up purposes, because then that we will right away get our lawyers and try to figure out why we're not respecting this. This was an executive order. We know executive orders are not perfect. Trump has taught us that, and that the next person in power can come and take them away, but we feel that it's a really important protection at the state level. At the city level, we just also passed a law last Tuesday. It still needs to be signed by the mayor, and the mayor may want to try to veto it, but we're confident that we'll have the overriding votes, which is that no municipal employee can spend resources collaborating with ICE. And so that's huge, because it means actually that NYPD can no longer make like friendly phone calls or anything. By resources, it includes people's time. So the law just passed on Tuesday, and is stated on Halloween. The law is the number of the law is 1568A, and we have to wait for the mayor and to see how the mayor is going to react. And to override a veto, you have to have more than 34 votes. We passed this law with 42 votes, so we are confident that this will move forward. But again, it says that like if you go to Medicaid, they're only going to ask you your immigration status because it has to do with your application, but that they can't share that with anybody. If you go to another agency where immigration is not a relevant thing for the application that you're doing or whatever paperwork you may be doing with a city agency, then they cannot ask for the immigration status. They cannot share that. The individual cannot collaborate with ICE, cannot be talking to ICE. I think unless there's like some sort of criminal investigation, in which case they have to have the right paperwork. And hopefully we're fighting so that in November we can also gather all the votes to pass a law that will be about ICE not being able to be in sensitive locations. Specifically, we're looking for the courts. We're looking to say that ICE cannot be in front of the courts. And so, as you heard, ICE is really mad at people like us in New York. We don't care. We kind of do want to make their life and their work harder, because we just don't believe that the way that they're going about the work for immigrants is the right way. But also, like, the important piece about all of you here in the room is that a lot of the ways that we push for legislation is based on people's experience. So when we're able to document that, so you as an agency should always be documenting what you're seeing. And then if you can, you talk to NICLU, you talk to, us at Make the Road, you talk to another like group of folks who are pushing policy and say, this is what we're seeing. And that helps our advocacy to push for laws that would actually help our community members. I think the last thing I will say is, when lawyers are not able to stop a deportation on their own, we do an organizing campaign. We have a manual. We can help and share. We can do trainings, all of this for free, about how do you do an organizing campaign on an individual to stop that deportation. That's actually a lot of work, but in a lot of cases, we're able to fight to get that person to stay here. We gather all this stuff to make a judge feel compelled that this person is important, like a contributor to society, and that they should stay here. So we can teach you about that. But you as agencies, if you feel okay with it, should always feel comfortable to write a letter of support for an individual. That actually means a lot when you're fighting for an individual to stay in this country, to say like, they come to my library, they come to my agency, they're like an important person here, like their moral character seems a nice one, and one that always comes to class or always comes to whatever program, and that helps their individual case. I'll leave it there.
Thank you. Thanks for sharing that. I love the idea of the signage as a kind of affirmation, not just to enforcement agents, but of course to clients. It's great. We're going to do a couple of hypos quickly, but I would also like, if people have questions, that they write them on cards so that we can start to gather them. We'll do that in the next couple of minutes. And so we'll be able to take questions from all of you. But I want to turn to our great panel and set up a couple of hypotheticals. So let's say I run a social service organization, and ICE agents come into our building and they stop at our reception area where they show a badge and they tell our receptionist they're looking for a client of ours. It just so happens that that client is in our offices today. What should we do? Do we need to give information about this client? Assuming they have no warrant, what happens next? What if they ask, we just want to know if that person is here. We don't want any confidential information. Emily?
No, 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 and no. that enough detail? I mean, I think that answered all of your questions. No warrant, no talk.
So they're persistent, although they have no warrant. What if they ask something more general, like, do you provide legal services to clients? Can we make them, okay, so let me stop there. What about that?
I'm not going to talk to you without a warrant or without my attorney present. You have no obligation to say anything.
Can we make them wait out front while line staff call for an advocate?
Yes.
And can we make them wait while we call our lawyers?
Yes.
And can we step away from the agents and leave them there?
Yes, but not advisable.
Okay.
I think having someone with them at all times, reasonable distance, not in their face, is the smartest way to handle that.
And can we ask agents their name?
Absolutely, and badge number.
And are we compelled to answer their questions? I think you.
You are not. You have the right to remain silent. Absolutely.
And are there penalties for not answering questions?
Not without some sort of judicial warrant requiring you to produce someone or produce documents. There is no obligation to do anything.
Anyone want to add anything to that?
I would just additionally either document everything they're doing, asking, and if I can't, record it.
Now, Jeff, what if that same agent were to walk into my agency and produce a subpoena? What's the very first thing I should do?
Check whether it's a subpoena or a judicial warrant, as we've been talking about. If it's a judicial warrant, they have the right to search the premises. But if it's not, all you should do is take it. They can serve it on you, so you have to take it, but note down exactly what it says, what time they gave it to you, who gave it to you, said thank you very much, and then they don't have any rights to do anything else. And call your lawyer immediately.
Great. I'm a senior staff member at a settlement house. I know many of you work at settlement houses. I was just notified by our office manager that there's an ICE agent sitting in our lobby. What should I do?
I think we sort of talked about this before. If they're sitting there, quietly, not causing any kind of disturbance, you sort of have no options at that point but to let them do it. I think the line is really if they're causing a disturbance in a way that any member of the public would not be allowed to do, then you can ask them to leave. And I will just concur that the response should be, if the response is no, that's information that should be recorded and reported to civil rights organizations like NYCLU.
Could I escort clients out of the back of the facility to avoid an encounter with ICE?
If there is no judicial warrant, absolutely. If there is a judicial warrant that has their name on it, absolutely not.
Anyone want to add? Could I harbor a client if I know ICE is looking for them?
I think the same answer.
Yeah. And I guess, what would the penalties be? Do we know what penalties would be?
That is not an area that I know a ton about. So I'm going to punt it to anyone else on the panel that knows more. I mean, civil prosecution, but not arrest.
Yeah.
Although I will say that, I once worked on a case where U.S. citizens were detained by ICE. So, I mean, I don't want to say that there are no penalties, but could someone get caught up in a enforcement action improperly? The answer is, unfortunately, yes.
I'm the general counsel for a community-based healthcare organization. Coming back from lunch one day, one of my colleagues spotted an ICE van parked outside our offices. What can we do? Can we take photos? Can we call and speak to the press? Can we address the ICE agents? Paige, you're nodding.
Yes, I would say all of the above.
And then call Natalia, who can tell you how to organize your response.
And I will also say, sometimes photographs are so powerful. We've seen some enforcement actions recently that people get really fired up about and we have a lot of response to. And those are actually very common enforcement tactics. And the difference was that there was a photo and there was an attempt to convey the information. So there's value there.
Yeah, I mean, I would echo that. I think sometimes we feel very powerless against agencies like ICE because they seem to be often beyond the reach of the law, because once they violated the law, oftentimes the subject of that action is already gone, is deported or removed. But, obviously we can't necessarily help that person if that's happened, but the next person can be helped. And there have been a lot of lawsuits that challenge patterns or practices of official conduct that is not in keeping with the laws and the constitutional protections of this country. And so as first responders on the streets and in our places of employment, we have the power to start recording that. So definitely play that part if you see something that you think is not kosher.
Great. Thank you. Very helpful. We're going to switch gears and look at your questions, which are amazing, complicated, and all very different from each other. I was hoping that they would sort of be organized neatly, but we're going to get to as many of them as we can. So one of you asked, some funders ask, and this is about data, some funders ask for information about immigration status. Should we stop, and I'm not sure we have the answer, we're going to have the answer to this question today. Should we stop collecting this information? Should we stop tracking this information about status where it isn't relevant to a client's legal case? And is there other demographic information we should consider not collecting? So this is funder-driven, I guess, data collection where immigration status is being collected. Was the person who asked this question at a legal service provider or a social service organization? Legal service provider. Okay. Do you want to take a stab at this?
I would take a stab at it.
Yeah.
It obviously depends on facts and circumstances.
Yeah.
But it's a very hard question. It depends entirely on, the funder. I think if that's a funder requirement, that's something you need to discuss with the funder. It's not something where there's a legal answer. It's if you have a policy of not collecting that information, and you can discuss that and explain that to the funder, that might be the easiest first step. But they can have whatever requirements that they would want, and it's up to you to negotiate that. I don't know if anybody else has a different.
I was just going to say, we try and collect as little information as possible for this reason, but maybe you could just have blind data. If they want to know that 40% or more of people are undocumented, you could just keep that information without having it tied to any individual person's record.
I think my concern is when we submit reports to the funders, there's not information attached to it would be 40% of status, but somewhere in our system we have information that was collected during is that collectible by law?
Pretty much everything is collectible by law enforcement.
But yeah, they're legal services.
Correct. If you're a legal services organization, if it's in your client's file, that should be protected. If they're telling you their legal status is part of your representation and working with them as a client, that should be protected by the attorney-client privilege and work product. But to the extent, I think that your instinct is right. To the extent you don't have to have that in your files, there's reason not to.
And someone asked a similar question, just a more general question, which I think probably relates to all of our organizations. Are client databases protected under attorney-client privilege? Well, this is for a legal services organization. So this is just about general client data. What about organizations' membership database related to a legal service organization? And I think there, again, probably your answer would be...
I'm not sure I understand the distinction between a membership database and a client database, but the most protection under New York law and federal law is for documents that are for a legal services organization that are in a client file. If there's a specific file that is marked, clearly delineated, says attorney-client privilege, work product, if you take steps up front to make clear that you're keeping this data as attorney-client privilege information, that goes a long way and is the most clear way of protecting it. To the extent it's on Excel spreadsheets and and other and non-lawyers have access to it or inputting it, that's less protected. But I'm not sure.
And I think members could refer to anything such as donors, and it would be a more broad category.
Yeah,
probably.
donor information would generally not be considered protected by the attorney-client privilege.
That makes sense.
I just want to add that there's a kind of like ways for you to protect the information for your members. If you're a community organization, not like a legal entity, you should probably not be collecting their immigration status. If you're collecting immigration status, then don't collect the name or the last name. Just put like first letter of the name and first letter of the last name. I would also be very wary about Excel sheets and sharing Excel sheets over email, Google Drive. We at Make the Road also are worried about hackers, not only subpoenas. And so we've also tried to figure out how to get all of our database encrypted. I know that this is like not fun stuff, but I think we're in the time and age where it's our responsibility to the folks who come into our office, into our community center, to know that their information is protected. So I will try to figure out ways where you can share what you need, but not make it so easy, because whether it's a subpoena or whether it's a hacker, if they get people's name, last name, date of birth, and address, and immigration status, that's like super easy for whoever is trying to find this info.
Thanks. This is school. Actually, this is specific to kids and reporting requirements for ACS or I guess now called SCR, right? Say it again. The State Central Registry. Okay. So as mandated reporters, how can we protect undocumented minors when we are mandated to call the State Central Registry? I know they don't have to disclose status, but what beyond that? And this is a very specific question. Did you all ask this? Yeah. Okay. Will the State Central Registry or ACS call ICE? So this is more to this question about the connectivity between agencies. Will ACS report family members who call and are undocumented? Yeah. Yeah, that's a great question and very specific, and about the sharing of data. And I don't know, Natalia, if the bill that you were talking about, or does that cover this?
The executive order at the state level covers that that information should not be shared. And yeah, like there should be no sharing between the agencies. One thing that I will tell you is, from my experience with community members in the past, also, when we work in schools, we're mandated reporters. We reported, and then the investigation led to one of the people in the house to be deported. But that's because they were in direct contact with what was happening, with the harm that young person was receiving. So that's like another piece, and that I think we have nothing to do around. But in terms of like, oh, we found somebody else in the house on the couch, they're not supposed to share that info. The minor is not supposed to. The awful thing is that we've seen ICE trying to figure out, like the case that she was talking about, the hospital was a 10-year-old in a hospital. So at the end of the day, if the ICE agent has a specific feeling about all the people they're going to try to figure out how to pursue, they're not supposed to.
I mean, I would say that this is a great piece of advice to seek from Marnie's folks, and find a lawyer that's willing to advise you on how to protect your organization and your clients on that issue.
Yeah. Yeah. So we're back to data. So people, I think, have a lot of questions about data. What happens with an organization that refers a client to legal advisors? Should we be destroying our client's interview documents as soon as the client is referred to the attorney?
Great question.
It is a good question.
Destruction of documents.
Yeah, destroying documents is generally not advisable. I think the way to think about that is, if you are contemplating referring somebody to a legal services organization and you take notes, I would do that under the guise or counsel of a lawyer from the beginning, and that way the notes would be subject to some sort of protection. And rather than destroying anything, send it to the lawyer and let the lawyer keep it in the lawyer's files, because those are going to be more protected. If you're not a legal services organization, the lawyer's files will be more well protected than yours, if that makes sense.
I mean, I would also imagine that there are instances, I'm just sort of thinking through this, I'm not in your chairs, but where you might be dealing with social services that or benefits that might be accessible to documented people but not to undocumented people. And that's a tough position to be in if you're not a legal services provider, because you do need that information, but it wouldn't be protected by any of the attorney-client privilege that we've talked about. So I think that might be a really interesting advice piece, Marnie. I mean, I don't know that I have great thoughts other than, there's certainly coding you could come up with that wouldn't be readily obvious to someone who's looking at your documents, and that could delay things for a while, not to, obstruct, but just as a manner of like not giving the information so readily in that documentation. But I think that could be a really interesting supplement to this guide, because I think that that's got to be something that a lot of you are facing.
Yeah, that's a good point. Someone asks about kind of the overlay with this, with really criminal law procedure in a way, and they're saying, well, like, no Miranda rights? Like, what's the deal? Like, why or do people not? I mean, this person is basically asking, are people not going to be read their Miranda rights in this context? I don't know if anyone wants to speak to that.
I mean, if it's a judicial warrant and they're doing it appropriately, they should be, but it doesn't often happen. The defect there is very, it's post hoc enforcement issues, which, once the person's been detained or removed is like a little bit unenforceable at that point. Any defect in the detention itself is not really challengeable for that person because they're in removal proceedings, and that civil action doesn't have any connectivity to their removal proceedings. So it's more about the pattern or practice of violations that can help other people, but for that person, it's a hollow violation.
Which is why it's important to get education and make sure everybody knows ahead of time what's happening and that they have those rights.
This is about schools, and I don't know if the person that asked this was thinking about public schools. Who asked the school question? Were you thinking about public schools? What can a school reasonably request and expect that school safety can do to not collaborate or coordinate with law enforcement and ICE? And I think New York City schools have issued a policy around this that I don't know if everyone is aware of, but that talk about.
We pushed for that. We said that the mayor basically said that because the schools in New York are mayor control, that no one can enter a school unless they have a judicial warrant, in which case they have to call the superintendent. Actually, not the principal, not a guard, no anyone in the school can give ICE right to enter school. They have to actually call the superintendent.
You're thinking about ICE working in cooperation with school safety officers. Yeah.
And they could see that as a requirement. So I was just going to draw up, the school safety.
Yeah, it's a good point. I mean, to my knowledge, that school's policy has been widely disseminated to the schools, to the principals, and to safety officers. But you raise a good point, and
I could get fired if they don't cooperate with police.
Right, you sort of more about atmospherics, right?
I mean, I think also just making sure that people are trained on like that whole police ruse thing, and making sure that they understand that they may be wearing uniforms that say police, but if they're not wearing NYPD uniforms, they don't have an NYPD badge, they are not police.
Natalia, are you aware of, I'm not, but I know a letter was sent in the schools that my kids go to, and I saw the official letter from the DOE and from the mayor's office, but Are you aware of what kind of training has gone on the ground in terms of, or other people in the audience aware of what's gone on the ground throughout the city in terms of the schools and school safety officers?
My understanding is that they did train all of the staff to say that, again, ICE cannot enter, they need a warrant, they have to call the superintendent. For the most part, we've seen it work. We've heard rumors and don't have proof of this yet, where they have entered schools around gang activity investigation. Which is what is really unfortunate about the whole criminalization of our folks, because, when it comes to gangs, then they, like everybody wants them gone. So then it gives both school agents, police, and ICE more force to implement whatever it is that they implement. And so we've heard of 2 cases. I think one of them was in the Bronx. We definitely have heard of this in Long Island. This has definitely happened in Long Island. But in terms of anything else, we haven't heard of ICE entering a school to ask for a student.
How does immigration enforcement actions interact with immigration protections for domestic violence? And I think, Jeffrey, you spoke about this a little bit, and trafficking victims. Anyone want to? Sort of very specific, but.
Can you say?
Yeah, can you read
The question seems vague. I'm not sure exactly what.
Yeah, who asked the question? Are they still here? Yes.
So, and then trafficking victims that are also endless violence with military victims. So, are there caveats that we can? Is this just kind of a broad stroke that I can? I'm not really sure how that. Working if they have special visits because of the
So you're talking about people who are here under VAWA or here under immigration, have immigration status. So their status is tied to.
I may be misunderstanding the question, so I may be saying something totally off base for you, but if someone has a U, a T, visa, or VAWA status, those people are here legally with documentation. They should not be messed with. But if you're talking about people who are undocumented being served by organizations that focus on those communities, that's a different question. So
if they have visas,
I mean, absent criminal activity, I mean, obviously, if I hold a U visa and I murder someone, I can be picked up for that. So it's not, it's not immunity against any kind of interaction with the law enforcement world, but it is immunity against being removed from this country, absent judicial proceedings.
Thank you. Sure. So the question is, are people with pending status vulnerable? With pending T or U or any status, any immigration status?
They're supposed to be not removable. Yeah. So, I mean, we recommend, this is just sort of practical advice, and there are others who are immigration practitioners in the audience. I'm looking at Sarah. You probably could say more about this, but, we recommend our clients carry that documentation on you, so that you can say, I'm here with a pending U visa or VAWA. And that's why we've been hustling to get those filed in volume, because for people that are eligible, that's a really important thing to have in the pipeline.
But I just want to say everyone's vulnerable, right? Unless you're a citizen, and even then you share a story of a citizen being picked up by ICE. If they ultimately want to pick you up for whatever reason, they're they break the law all the time. You're vulnerable. So yes, have some documentation. I usually advise people to have copies, not the originals. Don't have your home passport ever with you, ever, ever, ever. Hide it so that somebody in your home knows where that other country passport is, but not easy to find for law enforcement. And try to figure out how to have either someone that you love or a lawyer's contact close to you if anything happens.
A lawyer's card, if you're working with a lawyer who's filed that application, should be carried with you at all times, for sure.
Yes.
just a comment that pending the application
actions do not make somebody non-removable. So
Yeah.
there is a defense if they are put into proceedings. We could have a defense to be removed, but they could still be arrested and detained by ICE. And it's the same advice should really be given to people not to answer questions, not to have documents on them that show that they're from a foreign country, because that does make it easier for ICE to remove them. So that's just one example.
Thank you.
We could go down the whole rabbit hole of like the different ways that people get removed, which we won't, but there's judicial processes for some people and less judicial processes for others. And if someone did get detained as part of a sweep who's got a pending petition, then, you know, that's obviously a better scenario to be in than someone who's totally undocumented and has no pending status.
One of you asked, works with international students. Are you still out there? Great. So you asked, we are authorized to enroll international students through visas, through Homeland Security. And we have many students from immigrant communities. And I guess you were interested, what was your question? You were the intersectionality of. The exposure of the students that don't have visas. So in your program, it's blended between students who have visas through Homeland Security and those that don't. Yes. Yeah. I think it's so Homeland Security is in the mix with you because you have such a high population of immigrants, including those with visas. So you're interacting with them in a heightened way, it sounds like. I see.
Are you required to keep? Are you required to keep information about status for any reason?
Yeah, that's something we could look at with you. It seems very specific because it's unusual to have such a large group of people that are there with visas through Homeland Security. So if you're interacting with ICE a lot, I think it sounds like you may want to look at some of your practices in kind of a different way. Those all seem like great questions. I don't know that we can parse it all out today. Sorry. That's telling me our time is almost up. There's lots more great questions. We're not going to get to all of them, but I want to thank you all for raising all these questions. I want to invite you to continue to raise questions with us through email, pick up the phone and call us. We're happy to filter questions and share them with our amazing panel and try to get information back to all of you to think about ways that we might gather again in this kind of forum, or we might publish additional information to push out to our community. So again, thank you to the panelists. You are amazing. And thank you all for taking your time today.